Minister Tufton faces allegations of bypassing due process in Dr. Hunter's censure case.
Hunter versus Tufton. And by the way, people, we're going to spend a great deal of time today talking about Minister Tufton. You know, we've been talking about him on Market Me and the clear violations of the Procurement Act or the procurement rules. And what you're going to see is that some of the same violations that the Auditor General discovered at the University Hospital of the West Indies, some of those same violations were committed in the Market Me case. That is a fact. And who's central to this? It's the same gentleman. It's Minister Tufton. He's there again. Let me just do where is the Hunter Tufton? Hunter. Okay. All right.
Again, one sec, Provost. Again, people that are watching live, if you do not see the red dot, click on the word live or touch the word live. You'll see the little red dot appear right beside it, okay?
All right. Let me start with this. Now, I'm not sure how many of you know about this case. It's Dr. Roger Hunter, who's the applicant, and he's up against the Honorable Minister, Dr. Christopher Tufton. Why? If you recall, Dr. Hunter was on a Wednesday night program with us, and then he went on other programs as well for a period of time. Why? Because the medical fraternity, they basically kicked him out. They censured him for a year since May of last year. But they made some grave errors. And even after the errors were pointed out, Professor, saying that you can't do this, you have to provide, a mechanism for an appeal, it was ignored. Here's what happened, folks. The medical fraternity decided that because of things that he said, he, meaning Dr. Hunter, that they were going to censure him. They're going to suspend his license. The problem is that there was no mechanism for him to appeal. Even though the law said you have to create a mechanism for an appeal. And unfortunately, this is not the copy I'm going to be showing you is not the copy I highlighted, so just bear with me with that. But let me just show you who Dr. Hunter is. It's essential that we figure out who this gentleman is. And we know who his attorney is. His attorney is Mr. Hugh Wildman, notable attorney in Jamaica, right? And just to go through a few of his accomplishments. What is Dr. Hunter asking the court to do? And if you look at 3, it says an order for certiorari, an order of mandamus, and also a declaration. And the declaration, that's easy for everyone to understand, because the declaration is saying that the respondent, meaning Dr. Tufton, failed to do what he was supposed to do, in that he did not appoint a medical appeal tribunal so that Dr. Hunter could appeal his censure, because that's part of due process in any democratic society, that You don't have one person making or one body making a decision and then that's it, it's final. Like how with the Global Jamaica Diaspora Council, if the electoral committee, if they said that, you know, we're going to reject somebody's candidate, they said it's final. That is nonsense. You must have an appeal process because people make mistakes. You must have an appeal process so that somebody, an aggrieved person, can come to you and say, listen, I think they made a mistake by doing this, by doing that. And then you have somebody who can listen with an independent ear, no bias, and say, okay, I understand what you're saying. And that's why we have appeals court. That's why we have appeals court. So he's asking the court to issue a declaration that Minister Tufton did not appoint a medical appeal tribunal as he should have under the law. That's 2. Certiorari, mandamus. Let me show you what those terms mean. Here we go. When you see these terms, and you'll see them from time, you'll see them in a lot of legal documents. Certiorari. All it is, it's an order. You're asking the court to issue an order invalidating a lower court, tribunal, or public authority, the decision made by those entities. So whatever decision they made or didn't make, you're saying, court, I want you to issue an order of certiorari, which is to say that whatever Dr. Tufton did was incorrect. It exceeded his authority. It was unlawful. And it could be omission or commission. It could be something that he did or something that he should have done but didn't do. Certiorari, remember, you'll see it from time to time. All it's saying is that, court, we're asking you to invalidate a decision made by a lower court or a tribunal or a public authority. And the purpose of that is to ensure that these entities, they don't just act willy-nilly, they act like, you know, like everything begins and everything ends with them. That you have to have what is called due process. And as I'll never forget my administrative law professor at Howard, J. Clay would say, he would ask the class, what is due process? And people start complaining, and he says, no, it is process that is due. That's all it is. And what certiorari is saying, that they should have issued due process to Mr. Hunter. So the fact that Minister Tufton did not establish a tribunal, they're saying, judge, issue an order of certiorari, basically telling the Minister Tufton that what you did was wrong. The second term, mandamus, that is an order compelling a public authority, a government official, or lower court to perform a duty they have failed or refused to carry out. So you see the 2 things. One is because Minister Tufton did not establish the tribunal, certiorari is saying, we're invalidating what you did or what you did or what you didn't do, but you should have. Whatever you did over there by not establishing this thing, we're saying it's invalid. And the second thing now, mandamus is saying, because it's invalid, we're now forcing you to go ahead and set up that appeals tribunal. So that's all it means. Certiorari, mandamus. Certiorari is commonly referred to as cert. It's just saying we're invalidating what you did. And mandamus is saying, in addition to invalidating what you did, we're now telling you, we're now compelling you, we're now ordering you to do it. That's it. So here we are now back to the application for leave to apply for judicial review. So they're filing this with the court saying, give us permission to go ahead and file an action, right? So the court now is going to take a look at this. So there it is, certiorari, mandamus, and a declaration. But I'm reading this thing and I'm very impressed with Dr. Hunter. Look at this. I'll just go through some of this stuff. He's a trained medical practitioner for approximately 30 years and is fully registered on the General Medical Council Register of the United Kingdom. Not just Jamaica. See it right, that's a United Kingdom. That's one. He's a specialist. He's on the specialist register of the General Medical Council of the UK in the field of neurological and spinal surgery. I'm curious as to why he wasn't the one who did the surgery on the Governor General. Maybe the Governor General wouldn't be walking with a cane today. Look at this. He graduated in 1996 from UA at the top of his class in the field of medicine and therapeutics. And he got numerous awards, including the Glaxo Wellcome Award for the top clinical medicine student. He's all over the place. I mean, this man is superb. Look at this. He went on to do further studies at for foreign medical graduates of the United States certificate, and in the year 2000 was awarded a categorical post in surgery in the Ivy League Health System of Columbia, New York, being in the top categorical match for the world, not just for the US, for the world. He was awarded the intercollegiate final examination in neurosurgery. We're talking about brain. Brain, we're talking about, no. This is not a, we call him, internist or a general practitioner, you have a sprained finger or something like that. This man is eminently qualified. In 2005, he was awarded the primary boards of the European Association of Neurological Societies. So you see, this man is, that's a brainiac, but he's outstanding. He's outstanding. In 2006, he was awarded the Doctorate of Medicine from UA, making him the only person in the world to have West Indian, British, and European final exams in neurosurgery. The only person in the world. That's Dr. Hunter. There it is. And it just goes on and on and on and on, his accomplishments. Believe me, when you read it, it sounds like, this can't be true. Because the man is eminently qualified. So what happened is, and I'll get to it, I'll go to his affidavit. I'll go to his affidavit now and show you what he's complaining about. Here it is. It has the same language as the submission I just read to you, but I'm going to show you why he's complaining. Okay, here it is. This one right here. Said sometime about May of 2025, a colleague, one of his colleagues, by the name of Minerva Fame. Now, I know this lady. How do I know this lady? She and I went to Meadowbrook. We're in the same class. Or we were in the same street. The same year. She was in the A stream, I was in the B stream, but we had some classes later on, and we went to sixth form together. She's now a medical doctor. She's been for quite some time. But according to Dr. Hunter, he said that Minerva Fame made negative remarks, said that he made negative remarks about his colleagues, and she reported him to the medical council. Now, I'm not taking any sides there. I don't know if it's true or not. All I can tell you is that this is in his sworn affidavit. What I'm more concerned about is what happened after. And what happened after was that they had a hearing. He was not invited. And he didn't have any knowledge. It is right here. The council purported to have a hearing in the absence of the applicant and without the knowledge of the applicant, because they never informed him about the allegations against him. Now, this is a violation of due process. You have to tell people why you're taking adverse action against them or why they're being considered for adverse action so that they can provide their side of the story. But they didn't do that. They didn't do that. And then they decided to suspend him. They said that he should be deregistered for a period of 1 year. And he found this out by WhatsApp, social media, the Gleaner, and the Observer. This is not how you do business. And here's why this is not how you do business, because Section 12 of the Medical Act says that if you suspend somebody, then you have to create a mechanism so that they can appeal that suspension. And then you decide. You either reject or you grant. You reject the application, the appeal, or you grant the appeal. And who's responsible for setting up the tribunal? Minister of Health. There it is. And look at what they did. They wrote to the attorney at law within the Ministry of Health on the 17th of November last year. And they said, listen, you need to set up this tribunal. Nothing happened. They sent a letter on the 20th. So there's one on the 17th, one on the 20th. Then they followed up with various telephone calls to this lady. And look, despite numerous attempts through Ms. Miller, there was no forthcoming answer from the ministry as to the establishment of the Medical Appeal Tribunal. Then Mr. Hugh Wildman contacted the respondent. He contacted Minister Tufton by way of WhatsApp calls and messages and said, look, you have to do this thing. You have to set up this Medical Appeal Tribunal, which you are mandated by law to do. What did Minister Tufton say? He said he would make inquiries and get back to Mr. Wildman. Then he came back and he said Dr. Hunter should write directly to him, to Minister Tufton, and copy to the permanent secretary in the Ministry of Health. That's not what the law says, Mr. Tufton. Minister Tufton, that's not what the law says. And we're going to show you something now. So essentially that's it. It goes on and on. But they tried to get him to set up this medical appeal, and he didn't. Now, let me show you something that came out. Here is the minutes of the meeting where they deregistered, suspended, censured Dr. Hunter. And I want to show you something. This is quite interesting. Here it is. There, right here where it says matters for discussion. They're saying that he displayed unprofessional behavior. He made disparaging comments about patients and other doctors in a viral voice note. And he said some of his colleagues were incompetent. And so they're going to suspend him, right? Now look at what Mrs. Langren, she is a lawyer for the council. Here she is, or she's a lawyer. Miss Langren, where is she? Here she is, right here. Miss Gloria Langren, legal counsel, right? So the lawyer on the board said to them, she said she discussed the legal grounds for taking action, and the members concluded that there was sufficient evidence to suspend him suspend the doctor without a formal hearing, as the law gives them the authority to do so. Now look at this. The lawyer, Mrs. Langren, said, you need to do an inquiry. And this Dr. Fraser said, no, we don't need a formal, we don't need a formal investigation is not necessary. We can do this on our own. We don't need it. Then another doctor, Professor Pantry, agreed with Dr. Fraser, or I should say Professor Pantry, another member, agreed with Dr. Fraser and said that, yeah, we can suspend Dr. Hunter without a formal inquiry. We can do it. And he said, we don't have to do it. We don't have to do a formal hearing. We can just suspend him, not a problem. Here's where it gets interesting. 11 out of 13 members of the board voted yes, that he should be sanctioned. So then they took another vote, whether his sanction should be 1 year or 6 months. 9 members voted that he should voted, with 8 people voting that he should get a 1-year sanction. And they agreed that they would send a letter to him. No. Let me show you something. This gentleman, this man, this Dr. Edwin Toller Reed, he should get a medal. You know why? He said, you can't suspend a man like that without complying with due process. Here it is right here. He said, you have to have due process. And he said, what we should do is we should send Dr. Hunter a cease and desist letter. Whatever it is that he's doing that we find to be objectionable, we should tell him, Dr. Hunter, please stop before disciplining him. Here it's right here. He said he suggested that consideration should be given to sending a cease and desist letter as a formal warning before the final decision to take disciplinary action was made. So you see what happened, people? This is a very easy case. It's that one person complained that Dr. Hunter was making disparaging remarks about patients and doctors. And the council said, okay, fine, we're gonna conduct a hearing. But we're not gonna tell him. We're not gonna give him his due process. We're just gonna do it amongst ourselves. And they did. And they said, we're gonna suspend him for a year. And the man had no opportunity to show up and present his side of the case. That's unfair. You know, it's unfair even without the law, but it's even worse because I'm going to show you what the law says. I'm going to show you what the law says. Here we go. The Medical Act. Let me add this thing. I had it. Okay, here we go. I had it highlighted. Now I have to just rush through it. Here it is. It said, there is, okay, hold on. There is hereby established for the purpose, hold on, for the purpose of what? Purpose of hearing appeals from the decision of the council. There it is. And it says the provisions of the second schedule shall have effect as to the constitution of the tribunal. So it's saying, 12 is saying, you have to set up a tribunal when you discipline somebody so that they have a chance to present their case. Right? Let me see. And then it talks about what look, it goes into detail what this tribunal can do. It says you can do this, you can do that. There it is. But let me show you a schedule. What is it? Schedule, the second schedule. Look at what second schedule says. That's the first schedule. Here is the second schedule. Here it is right here. Remember, Section 12 says you must set up this body to hear so that the people can appeal. And then second schedule, it tells you now how that appeal body should be set up. Look, it says the tribunal shall consist of a chairman, right? The members of the tribunal shall, and the minister is involved. May appoint any person to it. Any member of the tribunal, the chairman, the minister, and it goes on. It sets out the whole mechanism. But guess what? Our world-class minister, and I'm saying that facetiously, of health and wellness decide that, no, I'm not going to do that. I'm not going to do that. Or he says, no, write to me and then copy the permanent secretary and write to us. No, that's not what it says. Here it is right here. It says, there is hereby established for the purpose of hearing appeal from the decision a medical appeal tribunal. It's right there. Let me see if anything else is inside here.
So, based on hearsay, they had a meeting.
Yeah.
And suspended Dr. Hunter just because of whatever they heard. And the minister, because the minister said they should do it.
Yeah, well, what the minister was supposed to do, the minister was supposed to set up this body, this appeals body, so that whatever the council decided, right, the aggrieved person can then say, okay, you have suspended me. I want to exercise my right to appeal. The minister was supposed to set up the appeals tribunal so that Dr. Hunter could have gone to them and say, hey, whatever Minerva, Tim, and others said about me, false, and defend himself. But no such relief granted to him. Instead, they said, we're just going to suspend you and we don't even have to have a hearing and have you present. And the man found out through social media.
He found out through social media.
Yeah.
Okay.
And then they went to the board and they're saying, listen, we need to get this thing straightened out. We need to have the appeals. They went to the Minister of Health, and the Minister of Health said, yeah, just write to me and we shall deal with it, and blah, and nothing. And look how nebulous this thing is. Look at what they said. They said here, for the purposes of subsection 1, which is to punish someone, they say a registered medical practitioner shall be deemed guilty of conduct that is disgraceful in a professional respect if he, and this is what they did, they use G, does or fails to do anything or thing, the doing of which or the failure to do which, in the opinion of the council, is unprofessional or discreditable conduct. What's that?
So, what was this so egregious thing?
We don't know. Except to say that he said he made disparaging remarks about his colleagues and about patients.
Oh, in the voice note that was not presented?
We don't know. He doesn't know. He doesn't know.
So, the medical government, because this is what it boiled down to, right? The medical government decided that, this guy going to get put in the corner. Time out.
Yeah. Yeah, exactly. And look at this right. It says, upon allowing an appeal. Here's the word appeal again, Upon allowing an appeal from any decision of the council. The tribunal, that is this appeals tribunal, shall publish its decision in the Gazette. There it is right here. They're talking about a mechanism that's not in place. They're saying, the law is saying you must have this mechanism. And the mechanism was not in place and they suspended him and he couldn't appeal. This is terrible. This is atrocious. This is. Let me just move this here, Kev, because
That is one more reason why our medical professionals are going to find pasture elsewhere. Even if it's not so green, but it kind of yellow.
yeah. I mean, at least give the man a chance. The law says you're supposed to give him a chance. And you see how they ignore the law. They ignore the law. Because he went to them and he said, hey, under section 12, you're supposed to set this thing up and give me a chance to say my side of the story. What they really should have done when they had their meeting, they should have brought him in and said, yeah, let's hear what you have to say. That's what they should have done. But they didn't do that. They suspended him. And on top of that, they didn't set up the mechanism for him to appeal. This is a blatant violation of the law. Blatant. And who is present here? Minister Tufton. And who's present at UA Hospital? Minister Tufton. And who's present at Cornwall Regional? Minister Tufton. And who's present Market Me? Minister Tufton. And who's present with all of the spending that the Auditor General determined that they didn't provide sufficient records to justify the spending? Who's there? From the Ministry of Health and Wellness? Minister Tufton.
So how can he be all of these places when he has been singing on a beach in the grill about a cottage?
You flew me with that one there. I didn't see that one coming. Or how could it be when him sit down on a boat or something with a steel floating
At the river.
Yeah, I or I sell books in Atlanta when people are dead in Jamaica.
How can it be do?
Kevin, I don't know.